Good evening. Hi, Orange. By the way, my blue Akara's bred, apparently. They laid eggs on the bottom of a couple of sponge filter bases, but I have not been home all week, and they ate the eggs. So what are you going to do? Anyway, I am terribly busy, so we're going to try to fly through this. This is Chille de Castro versus the state of Nevada. Yes, he is suing the state of Nevada. I don't know why he's bearing the lead by presenting the Las Vegas Metropolitan Police Department in the lead. This is just asinine. I haven't read this. My best guess is there's definitely going to be a qualified immunity challenge. Definitely a 12b6 for qualified immunity. They're going to have to prove. Chille's going to have to prove that the specific actions that he's complaining of in this complaint, which again I have not read yet, so we're going to go through it the first time together. He's going to have to prove that these are well settled rights that have been violated. And I'm going to assume, having watched the video of his arrest, I am going to assume that these are not well settled rights which have been violated. I'm going to assume that he's suing for things that are not violations of his civil rights. So that's going to be my best guess. And if that fails, so let's just assume, just for shits and grins, let's just assume that it gets past the 12b6 qualified immunity challenge and any other 12b6 challenges out there, or 12b5s, or 12b whatever's out there. My next guess is that it is going to be stayed. There's the younger abstention doctrine. I am not an expert on the younger abstention doctrine. There are exceptions to it. The younger abstention doctrine, it's like a three-part test. It's like, is there a state proceeding going? Obviously, there has to be in order for the younger abstention doctrine to apply. The state proceeding has to involve like an important state interest, and criminal proceedings always tick that box. A state criminal proceeding always ticks box 1 and 2. And then the third element for whether or not the younger abstention applies is, does the state proceeding provide an adequate opportunity for the litigant to present their federal constitutional claims? And in criminal cases, you can always raise violations of your rights to quash various, like fruit of the poisonous trees. You can quash evidence if it is gained in violation of your federal rights, or if your federal rights are violated in the arrest. And obviously you could say my federal rights were violated in the arrest, and the arrest is unconstitutional, or what have you. There's ways you can raise it. So Chille has adequate means to address it in state criminal court. And so my guess is this is going to be barred by the younger abstention doctrine. Now, there are at least 2 exceptions, and I am not, again, a scholar on these, but there is something like a bad faith. So if the prosecutor knows that you're innocent and they still bring the charges, they're bad faith. That's a real hard one to win on, because basically you have to prove you're innocent in order to be able to proceed with the younger abstention doctrine, or to be able to proceed in federal court as the exception to the younger abstention doctrine. And then there's extraordinary circumstances, I believe, one that I'm not really, I don't know any example for that, but basically I think that's a catch-all if there really needs to be an exception in your specific case. But this is not Chille has not invented the wheel. This is a thing that has been done countless times by countless criminal defendants, and the court is going to treat it as the same way every other one of these has been treated. So 12b6 for qualified immunity. If that fails, which I don't suspect it will, then the younger abstention doctrine is going to at least pause this whole thing. All right. So now, again, I have not read this yet. We're going through it for the first time. He has filed this in the District Court of Nevada. Apparently, there's only one. He is suing the state of Nevada, as well as the Las Vegas Metropolitan Police Department, and 1, 2, 3, 4, 5, 6 other people plus 50 does. So, all right, let's get it. So, plaintiff, a member of the press who specifically records police interactions, was recording a police officer interaction outside of a roll and smoke barbecue in Southwest Las Vegas, Nevada. 5 Las Vegas Metropolitan police officers, including the officer that he was recording, under the guise of protecting the privacy of another citizen in public without reasonable suspicion that plaintiff was involved in any criminal activity, did interfere with and rob plaintiff of his liberties while he was in a place he was lawfully allowed to be, while plaintiff was performing constitutionally protected activities. I mean, that's one way of interpreting it. And just for the barbecue elitists out there, I'm going to guess that Nevada barbecue sucks balls. The officers detained plaintiff, handcuffed, arrested, battered, tortured, forced him into the back of a patrol vehicle, and searched him and his possessions. None of the defendants intervened to prevent the unreasonable detention, arrest, battery, torture, or searches. Sadly, the abusive treatment plaintiff endured for merely asserting his rights and recording the police is not unusual or surprising. The civil rights action seeks to vindicate plaintiff's constitutional and statutory rights and hold the officers and the department accountable for biased policing practices. So he's going to raise bias. I wonder what bias he's going to raise for their biased policing practices and the policies or absence of policies that resulted in these practices. Okay. So I don't know what kind of bias he's going to raise. Are they arresting him because he's black? Like, what bias? Because he dresses like a middle-aged soccer mom from the 90s? Like, why? What bias? And is it a constitutionally protected bias? Race, religion, color, gender. I mean, what bias? And then in order for there to be a Monell claim, which is basically saying that there are statute or policies in place, or there's a pattern, there's a tacit allowance of certain rights violations to happen. That's a Monell claim. Generally speaking, you have to allege there are policies in place. And now he's saying that there's policies or absence of policies. So that's going to be an interesting one. If he has to plead with specificity the policies. I mean, you can plead both ways in a complaint. You can plead both ways. You can say A and also not A in a complaint. That's fine. The problem is that they can essentially go for summary judgment on him. And if he can't pull a policy out of his ass, then I don't know where we're going to proceed. And he is also suing the state of Nevada. I can understand the Las Vegas Metropolitan Police Department. I could understand him suing the city of Las Vegas. But the Las Vegas Metropolitan Police Department is, I would guess, an arm, an extension of the city of Las Vegas, of them. I don't believe they're Nevada state troopers. So it's going to be interesting to see how he ropes in the state of Nevada. Interesting in this guy's really fucking retarded kind of way. Pardon my French. So plaintiff is an adult. Yeah, blah, blah, blah. And he's a resident of the state of California. Las Vegas Metropolitan Police Department is quasi-municipal. See again. So there we go. I mean, it is a sub-entity of the city. So I don't know how he's going to rope the state into it. And a political subdivision of the state of Nevada, created and regulated by NRS, which is the Nevada Revised Statutes, Chapter 258, and at all times relevant hereto, employed all of the individually named defendants. So he's roped in the Las Vegas Metropolitan Police Department, but saying NRS Chapter 258, NRS Chapter 258. We're going to show this tab. NRS definitions. There one police officer. Las Vegas. I don't know what the fuck is he on about here. So this is just defining what peace officers are, deputies, duties of a constable. Let's check for police. So this has to do with the state making certain categories of peacekeepers, but I'm not sure what he's talking about here. Is it in a political and created by NRS Chapter 258? I have no idea. Okay. That's about the dumbest way to try to rope in a state. I mean, all the state's going to do in this is they're going to send in an attorney, like a deputy attorney general or something like that, who's going to file a motion. It's not going to cost the state any money. The state doesn't care. The deputy attorney general isn't going to care. I mean, he gets paid the same either way. The taxpayers are just going to write checks for this stuff. They're not going to settle. The state doesn't care. This is a bad plan. Bad plan. I work with an attorney who has over 50 years of experience, and he always likes to say that the worst place to be is in like a 2v1 or a 3v1 or a 4v1. So Chille has chosen to set himself up for a 1 versus at least 3, probably. I'm surprised he didn't sue the city of Las Vegas. But interesting. So thanks for defining who the state of Nevada is. This officer, okay. This guy was a supervisor with the LVMPD. Okay. Dingle, what an unfortunate name. He's an officer. Sorensen is an officer. Sandoval is an officer. Doolittle is an officer. Well, that's weird. Defendant Officer Doolittle. All right, and then the does, etc., yada yada, bullshit, yada yada. Yeah, jurisdiction and venue, sure. He's suing under 1983, I'm sure. Yeah, 1983. $1988. Isn't that is that attorney's fees or is 1985 attorney's fees? 42 USC 1988. Attorney's fees. It is attorney's fees. So he's looking for attorney's fees. Or expert fees. I was going to say attorney's fees is probably pretty stupid because he's probably not going to have any attorney's fees because he's not an attorney. So, all right. So, and then general factual allegations. Okay, at approximately 4:30 p.m. Pacific. Thanks for, making sure that we knew it was Pacific time because we have the date, we have the location, and we have the time. People could generally figure out, like, they don't even know it's Pacific time because, they know what the time zone is there, but thanks. Plaintiff happened upon a police interaction between a woman sitting in a silver Hyundai Elantra and Bork, who was sitting in a Ford police interceptor. Ford, best car built. Ford trucks are the best trucks built. Fight me. With the LVMP logo on it and number 19084. Thanks for the details. Plaintiff does not know the woman's name, but will refer to her as Jane. Plaintiff started recording the police interaction on one of his phones, moved to a position approximately 10 feet away from Jane, And making sure not to become between Bork and Jane, he asked her if she was good. Are you okay? Within 6 seconds, Bork left his vehicle, got plaintiff's attention, told him to back up, which plaintiff immediately did, giving Bork an additional 5 feet. Bork told plaintiff to back up again or he would detain plaintiff, at which time plaintiff began asserting his rights to record the interaction, saying, I'm more than 10 feet away. I'm a member of the press. I have a right to be here. Bork threatened to detain plaintiff for obstructing and said she deserves privacy. This is not your business. Plaintiff continued to assert his rights and notified Bork that plaintiff was a member of the press, at which time Bork got upset and said he was detaining plaintiff. I don't think it was the fact that Chille asserted he was a member of the press that really escalated the interaction between Bork and Chille. Now, I think I said it before. I know I said it before. I just don't know if I said it like in public or on my Discord. But I was not particularly impressed by Bork. He was a little, he was a little hot to trot. I prefer it. I know a lot of people hate Chille, and I get it. Chille's a douchebag. I get it. I agree with you, but I like it when officers are a little bit more Andy Griffith about things. I like it when officers are a little bit more laid back. Hey, buddy, I get it. It's totally your right to film. Just do me a favor and don't interact with the person I have detained, please. Can you do that for me, buddy? Perfect. Thanks. I would have preferred that. So anyway, it's not going to cost. This isn't going to cost Bork any money. This is just going to be a nuisance lawsuit that isn't going to go anywhere. But think about how much nicer it would have looked. I get all of you are probably really jaded against Chille, but most people don't know who Chille is. And most people are going to see him and they think, yeah, he's a douchebag. But man, that Bork guy, yeah, he was pretty hot to trot. Like maybe not just jump up and try to push people around. My 2 cents. Plaintiff continued to assert his rights. I love it. I love it how specific he gets about what Bork did, but so unspecific about what he did. What are you doing? I'm asserting my rights. No mention of being a constitutional law scholar. Just asserting your rights. We're just going to blanket it in an assertion of rights. Not specifically what you say, just assertion of rights. And notified Bork that plaintiff was a member of the press, at which time Bork got upset and said he was detaining plaintiff. Bork told Jane to leave and started walking aggressively towards plaintiff as if to use force, and plaintiff took a step back to prevent any physical confrontation. I'm always reminded of, I've only seen a meme of it, a SpongeBob SquarePants meme with, I think it's Patrick Star is the name of the starfish. He was standing there menacingly. And, he started walking towards me aggressively. Well, what does that mean? How do you walk towards someone aggressively? Quickly? Did he pick up his pace? Was he reaching towards you while he was walking towards you? How do you walk towards someone aggressively? He's such an aggressive walker. Like in the Olympics where they're doing the Olympic walking and they shoulder each other while they're doing that weird walking thing they do. I don't know. Plaintiff continued to protest Bork putting his hands on him unnecessary. Pronouns are the bane of a well-written complaint's existence. Plaintiff continued to protest Bork placing Bork's hands on plaintiff unnecessarily. You really don't want to have a lot of pronouns in a complaint. If you know who the actors are, you should specify them, especially when it's he put his hands on him. Is Bork placing his hands on himself unnecessarily? Started aggressively jerking off while he's walking towards me. But Bork was patently interested. Did Kate start writing this? Did Kate write this part? Because Kate loves patently. Kate loves patently. Oh, Jesus. All right. So plaintiff continued to protest Bork placing his hands on him unnecessarily, but Bork was patently interested in manhandling plaintiff in some way and said, listen, I am going to put my hands on you. Bork did indeed batter plaintiff. Uh, Interesting. While plaintiff was firm in his verbal tone, he never screamed or yelled, he never threatened defendants, and never said or did anything that would have led a reasonable law enforcement officer to fear for their safety or to suspect that plaintiff committed or was planning on committing any crime. Had he committed a crime? Committed in the past, was committing, or was planning on committing. So we're missing the was committing. So could he suspect that plaintiff was committing a crime? I mean, he got plaintiff charged with a crime, so all you need is a probable cause. For the detention, all you need is reasonable suspicion. That's pretty low. Good luck. All he needed was reasonable suspicion, and a DA thought he had a probable cause. Huh. I mean, maybe a jury will see it differently. He did ask for a jury. There's a jury demand on this, so we'll see. We'll see what a jury thinks. We'll see if he gets a sympathetic jury, although he's never going to get it to a jury. He can't figure out what to do after filing the lawsuit. Like, that's it. He runs into a brick wall and stops. Plaintiff asked for a supervisor, and while continuing to protest against illegal detainment and the use of unnecessary force, plaintiff offered to walk to Bork's vehicle. Plaintiff offered to walk to Bork's vehicle, which seemed to be where the officer wanted to illegally detain plaintiff. If you're willing to do it, if you offer to do it, then it's no longer an illegal detention. You can always willingly give up your rights. So I don't know where you're going with that. As soon as plaintiff reached the vehicle, he was forcefully grabbed and told that he was being placed under arrest. Okay. Once you're placed under arrest, you can be forcefully grabbed. Plaintiff was patted down and placed in handcuffs. Plaintiff made defendants aware of a prior shoulder injury, and plaintiff was put in 2 pairs of handcuffs to adhere to his medical needs. Although later during the encounter, a defendant police officer would yank and squeeze forcefully on plaintiff's arm over and over and over unnecessarily. You know, I struggle sometimes with language. Another thing I struggle with is, why is Chille threatening to kick anyone's ass? Like, he's got a shoulder injury apparently that hurts him. He's got high knee pressure. I mean, I mean, if I was Chille, I would stop like saying I'm going to kick your ass to people, especially when you've advertised that you're basically decrepit. Plaintiff was soon surrounded by 4 different police officers. Now, why would you get surrounded by police officers? Why would you get surrounded by police officers? Well, it's because one police officer is having difficulty controlling you or controlling the situation, because you're not being cooperative, because you're not being compliant. Now defendants, where he continued, plaintiff was soon surrounded by 4 different police officers, now defendants, where he continued to protest. They had no valid reason to detain or arrest him. Yeah, okay. You're arrested though at that point. Like, you're subject to their control. Bork accused plaintiff of being on drugs based on the color of his skin. So Bork said, Chille, I think you're on drugs because you're white. Sounds legit. Plaintiff said that he did not have a criminal record, and Bork entered his vehicles to type up a report. Well, the fun fact is that the police are going to be able to see the same records that the judge in Massachusetts saw, and the police will get to see that Chille indeed has a GHB distribution, possession with intent to distribute, whatever, that he pled guilty to in exchange for a deferred adjudication. So he pled guilty to it. He had to, because at the time in California, the only way you could get it back in the, I think it was the 90s or the early 2000s? It was 2003. It was 2003. Back in 2003, the way the law was written, you had to plead guilty to get the deferred adjudication. You plead guilty, the judge would give you some thing to complete. You know, you have to stay clean for this amount of time, blah, 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 do this and that. And then at the end of that, if you completed that deferred adjudication successfully, then the charge would be dismissed with prejudice or something like that. But at that time, back in the early 2000s, you had to plead guilty. So Chille pled guilty to it. It is on his record. It will show up on his record, just like it showed up on the record for the Massachusetts judge. That's the way California law worked back then. It's different now. Now you don't have to plead guilty to it. But back then, you had to plead guilty to it. Now you have to plead not guilty to it in order to get the deferred adjudication deal. Back then, you had to plead guilty. So he has a criminal record. I mean, if the I don't know why he's hanging on to this so hard. He has a criminal record. He might not have a conviction, but he has a criminal record. Like, let it go, bro. Like, methinks thou dost protest too much. Soon after, one of the defendant officers demanded that plaintiff look only straight ahead, and when plaintiff did not immediately comply, the defendant began squeezing plaintiff's elbow, placing pressure on the ulnar nerve. Pain compliance. Oh my. Plaintiff complained about the pain and protested against needing to look in a specific direction to have an arrest effectuated on him. Well, I don't like your policies. The defendant squeezing plaintiff's elbow said it was within their policy to squeeze elbows for people in their custody that did not comply with random commands that would grant complete dominion over another human being, from which way plaintiff's head could turn to his right to use speech or when he could blink. Yes, they have a lot more control over you when you're under arrest than when you're free. Surprise, surprise. As you know, I want to hold a rally inside prison. I want to dress the way I want to inside prison. Why do I have to sleep in this bunk? Why can't I choose which bunk I want to sleep in prison? Plaintiff did experience severe pain and paresthesia from the compression of his ulnar nerve. Well, but did you go to a doctor for it? When plaintiff pleaded for help from the surrounding defendant officers, they completely ignored plaintiff. Oh my. Plaintiff told them, "You're going to be sued for failing, capital F, failing to intervene. I'm sitting here telling you this man is torturing me. Please ask him to stop." Plaintiff was ignored by all sworn peace officers on the scene, who are now defendants. Well, boy, howdy, I'm sure they're really regretting not intervening. Plaintiff's elbow was squeezed for approximately 15 minutes in total before plaintiff's pain tolerance forced him to tear his elbow away from the defendant officer. Did you ever think about, I don't know, looking in the direction they told you to look? Would that have stopped it? I don't know. Just spitballing here. At some point, defendant Torrey, the supervisor, arrived on the scene, authorized the defendant's behavior as being within their policy. Torrey then stated the plaintiff should be arrested to discourage plaintiff's behavior. I'm sure that he said that, since that was in quotes. All the defendants on the scene knew that there was no reasonable suspicion or probable cause to suspect plaintiff of any crimes, but wrongfully believed that they were justified in detaining plaintiff for assertion of his civil rights and for refusing to cooperate with the defendant's feelings and ridiculous, unreasonable demands of a law-abiding citizen. I'm convinced. Bork engaged in profiling against members of the press when he stated that First Amendment auditors have been known for dropping their phones, pulling out guns, and shooting at officers, which is preposterous and provably false. So Chille is going to get every video of every encounter ever where anybody has ever shot at police officers. And he's going to review them to see if there was someone who dropped their phone and pulled out a gun and shot at the officer. Or he's going to quibble that, oh, those aren't First Amendment auditors or something. I don't know. I don't think he understands how hard it is to prove something like that never happened. It probably did happen. At some point in time, someone probably dropped their phone, pulled out a gun, and shot at a cop. Probably. Just pure odds. Someone somewhere probably did it. Someone probably had a phone in their hand, at some point in time, dropped it, pulled a gun, and shot at a cop. A defendant officer said that plaintiff needed to be patted down again. Plaintiff protested he'd already been patted down by two officers. The officer then spread plaintiff's legs uncomfortably wide and purposely and maliciously, with significant force, struck plaintiff in the testicles with what felt like a closed fist. Plaintiff yelled in pain, quote, "I can't believe you just hit me in the nuts," end quote. Well, if plaintiff yelled that and then quoted it in his complaint, it must be true. This is the worst fisting I ever got. Plaintiff was forcibly placed into a police vehicle by defendants who pulled the seatbelt as tight as they could, knocking the air out of plaintiff. They put my seatbelt on too tight and knocked the air out of my lungs. Oh, there's a certain amount of retard that just really hurts. They put my seatbelt on so tight it knocked the air out of my lungs. Torture by seatbelt. Fuck me. B. Sorensen attempt to get plaintiff arrested for NRS 202.487. Okay, let's try that. NRS 202.487. Share this tab instead. This is impossibly hard to read, and I apologize. Make it a little bit bigger. 202.4. What was it? 202, 487. 487. Leaving a pet unattended in a motor vehicle. Okay. Without limitation, extremely or cold. Okay. Any peace officer who reasonably believes that a violation of the section has occurred may use reasonable means. Okay. Peace officer or animals use. Okay. Pet that is removed is deemed to be an animal treated cruelly. Person required to take possession of pet may take action. Provisions of section do not interfere with prohibited activity. With person violates misdemeanor. Okay. All right. So they tried to get him arrested for leaving his pet unattended in a motor vehicle. Okay. Even though plaintiff's animal was not in unsafe conditions. Well, let's look at this again. To remain unattended in a parked or standing motor vehicle if conditions, including without limitation. So these are examples, but this isn't the entire list. Extreme heat or cold present a significant risk to the health and safety of the pet. Okay. I wonder if leaving the animal locked up while you go and get arrested would place the animal in would represent a significant risk to the health of the pet. I mean, is there adequate food and water in there for it until you get out? I don't know. I mean, it seems like a pretty shitty thing to do. I mean, if you arrest a guy, basically, if you're the one who's making it so he can't care for the pet, and then arrest him for not being able to take care of the pet, that'd be kind of shitty. But I mean, I can see why the officer might have reasonable suspicion that even probable cause. I can see how an officer could believe he had probable cause on that. It would be interesting to see. It'd be interesting to see if this gets litigated, how this breaks down. It won't get litigated, but it would be interesting to see how it plays out. I could see arguments being made on both sides. Plaintiff was searched and transported to the Clark County Jail. Oh, by the way, this is the first time I'm reading this, so I haven't done any research on NRS 202.487. So I don't know any case law on it. I mean, maybe it's already black and white. I don't know. So he was searched and transported to Clark County Jail, where he would not be formally charged, but only released with citations. What the fuck do you think those citations are, you dumb shit? Sorry. Approximately 5 hours after the incident began. Like, what are you expecting? Like a ceremony? They release you with the citations. That gives the DA time to do whatever he needs to do and initiate any legal action against you. He needs to start. That's one real frustrating thing, like you get a client in, that client's arrested. I always end up calling the bail bondsman because they always know what's up. But like you call the court, like, oh, it's on this case number. Like, oh, that case number doesn't exist yet. The DA hasn't actually, they've reserved that case number, but they haven't actually filed anything on it yet. And, then you have to actually wait for the DA to get back to you. And sometimes that can take forever because they don't want to show you anything until they're ready to file, until they have to show you something. And it's a real shitty situation. The officer's actions left plaintiff in the position where he had to pay for a ride back to his vehicle and did pay monies for such a ride. He had to Uber. On the arm the defendant squeezed, plaintiff was left with a severe bruise in his elbow area, continues to have paresthesia in his index and thumb, and requires ongoing medical care. Almost a month after the incident, B. Sorensen continues to harass plaintiff by warning him against violating NRS 202.47, although plaintiff has never left his pet in unsafe conditions. So by alleging this paresthesia, he's going to have to provide an expert. He's going to have to find an expert. Chille, listen up. You're going to have to get an expert. You're going to have to get a medical doctor who is going to examine you and write a report that, based on his observations and your past medical record, this paresthesia was, as a medical certainty, you want medical certainty, caused by squeezing of your elbow. And then he's going to have to say how much it's going to cost to have it fixed in the long run. We're never going to get to that point, obviously. I mean, your lawsuit's going to peter out, but that's what you would need to do. You can't just allege it. You're going to have to prove it. And the amount of money that you're going to get is based on however much money you've spent getting that arm taken care of and how much money the doctor thinks it's going to take for you to get that condition remedied. Now, another fun issue, since you have asked for a jury trial, Chille, is that you're going to have to convince a jury that that's a real thing, that you actually have this paresthesia, that it hurts you, that it causes you issues, etc. And they're going to look at this and they're going to say, well, this happened, a couple months ago, and you never saw a doctor for it. So how bad could it really hurt? How bad can it really hurt? That's the mindset of a juror. You really do need to start establishing your medical damages right away. And you need to keep them ongoing until the doctor clears you and says that, they've done everything they can for you. If you don't do that, then a reasonable juror might be led to believe that you did not, in fact, get injured and that did not, in fact, hurt you, or else you would have gone to the doctor. When people are hurt, when they're really injured, they go to the doctor and they seek medical treatment. And if you're not doing that, then they're going to assume that you're not really hurt. Even if you get a hired gun doctor to write a report and say that you were hurt, if you can't show those medical records where you sought medical care immediately after the incident, yada yada yada, you've really harmed your ability to recover. Almost a month after the incident, blah blah blah. Okay, so as a result of the defendant's actions, deprivation of rights, yada yada. At no time during the encounter with defendants did plaintiff do or say anything that would put a reasonable officer in fear of his or her safety. It's not something you have to do. He's on to this. I am not a huge fan of the whole officer safety thing, but officers can have, it doesn't have to be fear. It can have to be apprehension. It could be just a policy issue. It could be, as our policy, we handcuff people with their hands behind their back. As our policy issue, we take people out of the cars when we've detained them. As a policy issue, we leave people in their cars if we pull them over and detain them. As a policy issue, we make people who we've detained sit down cross-legged on the curb. And that's not necessarily saying they're afraid, but there's an apprehension. They are under the apprehension that there is potential danger to them out there. There's an adversarial relationship with the person that they've detained, and that person might respond violently. And it doesn't mean they're afraid. It means they have an apprehension of there could be some sort of violence resulting from this interaction. Obviously, Chille didn't want to get stopped. And, I've watched the video and I've seen Chille, push the officer and pull his arm away and things like that, which he could have been charged for. He could have, the charges he got were relatively light as far as what he was cited for. And that doesn't mean they won't go back and escalate and file new charges. They could still, at least my basic understanding of the law without knowing the specifics of Nevada law, I don't see why they could not at this point tack on extra charges. So, they definitely didn't overcharge him as much as they could have. Anyway, following the incident, Bork claimed in a written incident report that the reason why plaintiff was arrested was for engaging with a detained officer, refusing to give an officer reasonable space to work, and refusing to obey lawful commands after being advised that he was detained. A detained person's rights are only limited as to leaving. A detained person's rights are only limited as to leaving. I don't think that's true. I don't think that's true. Yeah, I don't think that's true at all. Like, a detained person could be frisked. You don't, an officer can't just come up and just like start groping you. But if they've detained you and they have a reasonable suspicion that you're armed, then if they have detained you and they have a reasonable suspicion that you're armed, a reasonable suspicion to justify the detention, yeah. But if they have a reasonable suspicion you're armed, then they can do a Terry frisk. Whereas you have a Fourth Amendment right to be secure in your body, and they can't just frisk you if you're not detained. You have less rights, and it's not limited as to leaving. So I don't know where he got that from. That's interesting. I mean, it's fun to put things like that in there, but he's at some point in time, I mean, a lawyer's going to look at that and be like, no, that's not right. And that lawyer is probably going to pull up some sort of a Nevada opinion that says, no, I mean, there's all sorts of rights that you lose while you're detained. You don't have the right to, I don't know, the officers can take away your your phone while you're being detained. They can prevent you from using a megaphone while you're being detained. They could prevent you from, I don't know, doing all sorts of things while you're detained. They could put you in handcuffs while you're detained. A police officer's, specifically defendant Bork's, feelings must be weighed against a citizen's rights. What does that mean? A police officer's feelings must be weighed against a citizen's rights. What does that mean? A police officer's feelings must be weighed against a citizen's rights. The defendant's behavior did not follow LVMPD's use of force policy interactions with public policy. We're just gonna say, like, what part did what the where which what where what The written report by Bork also claimed because DeCastro was physically uncooperative with officers, he was, admitted to being in trouble numerous times in the past for similar reasons, he did, and would not even allow officers to explain to him why he was detained or placed in handcuffs. He was arguing the entire time. We determined he was not a good candidate for a citation and release. Because of DeCastro's actions, it was clear that his criminal behavior would continue in the area if police did not act. Okay? I believe they got him for obstruction. Yeah, I mean, if they have to stop their whatever their call is, whatever they're doing, to deal with him every time, yeah, that's going to be a problem. The facts in the incident report were either fabricated or merely pretextual. Okay. Even if the facts set forth in defendant Bork's report were true, which the video evidence disputes, well, there you go. There you go. There you go. Now the video evidence has been referenced by the complaint, and the video reference is probably going to be admissible in a summary judgment or in a qualified immunity motion. And the video evidence is probably the last thing you wanted the judge to see. Now, I say that because it's going to end Chille's little lawsuit. Chille wants this to drag out. He wants it to go as close to trial as he can get it, in hopes that he's going to get, a big payday when the arrest lottery and actually get a winning civil suit. The problem is that he's now incorporated the video evidence into it, and so they could probably, the defense can probably use elements of the video to place into dispute what Chille is alleging in his complaint. So basically, normally in a 12b6, you have to take all the facts alleged in the complaint as true. If, however, you've incorporated a video into it, the court can watch the video. And the court can be like, well, I watched the video, and the video says that, and the video contradicts, paragraphs 1, 3, 5, and 7. And so I'm going to disregard those because the video evidence that you've provided contradicts the written thing that you said. So I don't have to accept those as being true anymore. And so it's more likely, because Chille incorporated the video, because he referenced it in the complaint, that the court is going to be able to dismiss some of his allegations as not being true for a summary judgment or a 12b6 motion. Those facts did not give rise to a reasonable suspicion to detain plaintiff, and certainly did not furnish probable cause to arrest plaintiff. I don't know why people put, I don't know why he put it in there. Like the facts in the incident report are either fabricated or pretextual. I mean, you could say that, sure, but then the rest is just a legal argument and is useless. especially since the only citation is to Terry versus Ohio. And in Terry versus Ohio, remember what the fact pattern was in Terry versus Ohio. Two guys were standing in a corner. One would walk up to a window of a store, look in, and walk back to the corner, and the two would talk. And this happened multiple times, like a dozen times maybe. And Officer McFadden was watching him. And then they met up with a third guy. And they were walking down the street, and he thought that there was an armed robbery going to go down from them looking into windows and then talking. And he pushed him into a store, and he patted him down, and he found a gun on Terry. And there you go. Because he suspected that they were going to commit armed robbery. That was a reasonable suspicion. Them walking up to a fucking window and walking back to a corner talking, doing that multiple times, was enough to give him reasonable suspicion that it was armed robbery. And because it was reasonable suspicion it was armed robbery, that implies armed, and so he could do the Terry frisk. I mean, it's laughably low. If an officer cannot establish reasonable suspicion in a report or in front of a judge, then that officer is not smart enough to be enforcing the law, because it is ludicrously stupid. Illinois v. Wardlow, guy standing at the corner of a building holding an opaque, meaning you can't see through it, bag, like a black bag that you'd get from a convenience store that, you know, they put like one or two things in there, or a liquor store, just a black bag, opaque, can't see through it. Maybe it's black, maybe it's not, but you can't see what's inside of it. Guy standing there with a bag full of something, with a bag with something in it. Don't know what it is. Police, 6 or 7 police roll into the area in squad cars. He sees them, they see him, see them, and he takes off running. Reasonable suspicion. Oh, it's a high crime area. People here are known to be drug dealers. And so because they're known to be drug dealers and they're known to carry firearms, then all of a sudden we have reasonable suspicion for the frisk as well. I mean, it's ludicrously low. At that point, a reasonable officer would have left the plaintiff alone. Bork never told plaintiff there was an investigation or that he was interfering with it. He had a car pulled over, dude. He doesn't have to tell you. He doesn't have to tell you. A reasonable person would understand that he has somebody pulled over. You saw it. Like, literally, that's what you went over there to do. I'm a news reporter. What were you doing? I'm walking up to random people in a parking lot. No, you saw that there was a person being pulled over. Rather, Bork only demanded plaintiff respect Jane's privacy in public. That was his only demand. Interesting. That was his only demand. I wonder if the video evidence says otherwise. Defendant Bork seemed only intent on preventing plaintiff from recording the police interaction. Perhaps this is because plaintiff has recently covered several stories about LVMPD that went viral on the internet. Oh, viral. That's news. Plaintiff is informed and believes and intends to prove after conducting relevant discovery the defendant's actions in detaining and or arresting plaintiff, using force on him, and illegally searching him and his belongings was motivated largely or entirely by the following. Well, okay, let's start off with the illegal search. Search incident to arrest. If you are arrested, they can search you. They don't need anything other than I've arrested him. I get to search him. I get to know what is in his possession and make sure that he's not carrying anything that he shouldn't be carrying when I place him in the back of the car or when I put him into the jail cell. I get to search him. It's no probable cause required, no reasonable suspicion required. Once you've been arrested, they get to search you. It doesn't matter what they arrested you for, they get to search you. Fourth Amendment, don't care. I'm going to put this person in the back of my patrol car. They're arrested. I'm going to put them in the back of my patrol car and take them to jail. I'm going to search them before I get them in the back of the patrol car. When I get them to the jail, they're going to get searched again. And they're probably going to get placed in an orange jumpsuit or whatever. And then they're probably going to get searched in the orange jumpsuit. just to make sure that they didn't like move anything from their street clothes to the orange jumpsuit. So yeah, I mean, he's not going to win any points on that. So the motivation, it's his position as a member of the press, which is not a protected class. It records police interactions for accountability. Plaintiff's negative viewpoint of police who all contribute or hold silent, the thin blue line, about police brutality. All police hold silent about police brutality. Well, if you label everything the police do as police brutality, then yeah. I mean, if everything the police do is police brutality, then sure. But not everything is police brutality. I mean, you're playing word games there. The police, nothing that I saw in the arrest was police brutality. They weren't punching him in the face. They did not treat him poorly at all that I could see. I didn't see police brutality, but maybe I'm wrong. Maybe it's Maybelline. And or plaintiff's verbal protestations of the defendant's actions and plaintiff's accusation that the defendants were harassing him. None of those are protected characteristics, so I don't really care why he's alleging this. Indeed, as shown on the video footage captured by plaintiff's cell phone and the video footage plaintiff expects to obtain for defendant body cams, plaintiff did not do or say anything that would have provided reasonable suspicion or probable cause for the detention and or arrest, excessive use of force, and subsequent searches. Therefore, there is a strong inference that the defendants were in fact motivated by one of the three factors enumerated above, but those don't matter. They're literally, they don't matter. Neves v. Bartlett, doesn't matter why the police make the arrest. All that matters is did they have probable cause to make the arrest. That's it. So we're doing a 1983. So they violated his rights under the Fourth Amendment to be free from detention without reasonable suspicion, free from arrest without probable cause, free from unreasonable search and seizure of property, right to be free from excessive force and unreasonable force and restraint in the course of an arrest. Actually, I think some of the stuff he was complaining about was excessive force after the arrest, which would be an Eighth Amendment violation. Just helping you out, buddy. But there you go. Oh, maybe you'll get to it. That's just bare pleading, 14th Amendment. Okay. Color of state law, violates rights under the Equal Protection Clause. They intentionally discriminated against him on the basis of the color of his skin. The color of his skin. Based on the color of his skin. Jason Torre and Jesse Sandoval. I'm sure they're big Aryan Brotherhood guys. Shit. All this time. Sorry, sharing the wrong page. Yes, I don't read chat. I'm sorry. Chat comes at the end. Oh, my bad. Well, you could figure it out because I was reading it out loud. All right. So based on the color of his skin, his position as the member is pressing due to his viewpoints. So discrimination based on the color of the skin is a protected characteristic. The member of the press is not, and viewpoints is not. Defendants would not have harassed, detained, arrested, used force on, and searched plaintiff if he had been more like them. Still, that has to be a protected class, and Officer Sandoval might think that you're a little bit like him. Or Torres. In particular, according to defendants' own incident reports, one of the facts upon which they relied in detaining and or arresting plaintiff is that there were previous incidents involving members of the press dropping their cameras and pulling out guns. Press or First Amendment auditors? That might be a distinction. Might not be. But again, being a member of the press isn't a protected characteristic. Choosing to detain plaintiff, a member of the press, and based on alleged actions and or involvement of other members of the press and due to the color of his skin, he's just throwing that in there. You actually have to prove skin color. Like if they called you like epithets about your ancestry, maybe that would do it. So it's, yeah, I don't know. He hasn't shown anything. He has proved no facts about the skin color, and he looks white. I would not suspect. Maybe it's because I'm dumb, but if I didn't know his name was Jose de Castro, I would not know that he had any Latinx, whatever, blood in him. I, you know, I he looks white to me. He looks white to me. If the defendants had been told the man of their skin color trying to get police officers' autographs instead of photographing police interactions for accountability had pulled guns on police, it is virtually certain the defense would never have detained, arrested, or searched such a person in the same parking lot. What the fuck does that even mean? If officers Sandoval and Torres had been told that a man of their skin color trying to get police officers' photographs had pulled guns on police, it is virtually certain the defendants would never would have arrested or detained, arrested, or searched such a person in the same parking lot. I think what he's trying to say is that police officers are like little rock stars, and they love to give out their autographs, and that they're willing to allow people to interfere with their traffic stops to get autographs. But I think that Chille's really glossing over the whole part where he inserted himself into the traffic stop. Like if he had stayed back and just filmed it, I don't think there'd be an issue. But he didn't. He inserted himself in it. He started talking to the detained person. Defendant subjected plaintiff to the wrongful conduct, blah, blah, blah. Yeah. Punitive damages, good job. No punitive damage was sought against defendant in Nevada. Well, that's quite gracious of you. All right. This is First Amendment violation. Okay. Under color of state law, this and that. Hold on a second. In particular, defendants retaliated against plaintiff for his speech, including his verbal protests and criticisms of the defendant's actions in investigating, detaining, and arresting plaintiffs. I guess not him? Then why is it capitalized? That doesn't make any sense. Is he referring to himself there as arresting him without any basis, or other plaintiffs? Because did they file lawsuits? Would they be suspects? Is he meaning to say suspects or protesters? I have no idea. Without any basis, and his exercise of his right to refuse to cooperate in what started as a consensual encounter. In particular, defendants retaliated against plaintiff for his speech, including his verbal protests and criticisms of the defendant's actions in investigating, detaining, and arresting him without any basis, and his exercise of his right to refuse to cooperate in what started as a consensual encounter. Do you have a right to refuse to cooperate in something that starts as a consensual encounter, but then moves to a detention and or arrest? Do you have the right to refuse to cooperate in that? Or is that resisting arrest? Is that obstructing? I don't know. I didn't know you had a right to do that. That'll be interesting to see what he pulls out. Plaintiff also believes defendants retaliated against him for refusing to cooperate in a consensual encounter, which is also protected activity under the First Amendment. I don't believe that is the case. Defendant subjected plaintiff to their wrongful conduct, blah, blah, blah. Punitive damages. Manel against LVMPD, Nevada, Tory and Doe's. All right. Customs policies and practices to carry out or tolerate, really? So Nevada's like, you know what? Let's just go ahead and detain people without reasonable suspicion. What does Nevada have to do with this? Nothing. LVMPD, sure, he could try to do these. Manel claims are hard to prove because what Chille's going to do is he's going to extrapolate from this one encounter out. And you can't do that. So, yeah, he's going to have to show like a series of events by LVMPD to establish the customs, policies, practices, and procedures to use excessive force, right? It's our policy to use excessive force. Blah, blah, blah. Fifth cause of action. Okay. 1981. They discriminated against him because of his race and political viewpoints. Are political viewpoints protected? I don't think they are, but maybe I'm wrong. I know they're trying to make them protected. I know there's been movements to make them protected. But I don't know that they're actually protected. Yeah, I don't think so. The race, sure, but good luck on that race discrimination. There are, you may find this hard to believe, but there are a lot of persons of Latin and Hispanic ancestry in the Las Vegas area. I don't think that officers Sandoval and Torres are really going to be, but anyway. Okay, blah, blah, blah. So I don't think that's going to work. Assault, physical action. So he's incorporating a state cause of action. So great. Malicious and oppressive for punitives. Sure, battery. Yeah. False arrest. Nice. I don't know. The DA brought charges, so somebody somewhere thought they had a probable cause. Invasion of privacy. Well, that's interesting. He had a reasonable expectation of privacy in his personal affairs, including the contents of his personal belongings. Invasion of privacy. Okay. Intruded. So invasion of privacy is usually like that tort is usually like if you're in some place where you have some reasonable expectation of privacy, like a movie star in their backyard or something, and somebody like films them or whatever. Something like that, something where you have like a reasonable expectation of privacy. Searching his belongings. I don't know how that would be an invasion of privacy. Did they actually get into the cell phones? That'd be interesting. I mean, if they had a warrant, then that's all gone away. If they had a warrant to get into the cell phones, then that's pretty much a done deal. Negligence, just plain up negligence, just straight up negligence. Suffered injuries and damages from negligence. Okay, like assault is an intentional tort, battery is an intentional tort. Negligence, usually like negligence involves some sort of harm, like if you get in an automobile accident, that would be negligent. Or if you bump into someone and knock them over and they fall over and break their arm, they might sue you for negligence. So 5 for compensatory damages in amount according to proof. So his costs are actually pretty minimal. The Uber ride is pretty small. Again, he's going to have to establish some sort of medicals. I don't think he's going to have them. He lost wages. I don't think he has any. His actual compensatory damages are going to be super duper low. And I think there is a constitutional cap of somewhere around 8 to 11 times, somewhere in that range for punitive damages. So let's say he can prove, let's say he goes to the doctor a couple times for his arm and they give him ibuprofen or whatever. So a couple doctor visits, let's say that he could show, and a couple bottles of ibuprofen. Let's say he could show $2,500 in medicals, and then the cost of an Uber ride. Let's be generous and say it's a $500 Uber ride, so $3,000. So best case scenario for the punitive damages would be somewhere about 10 times that. So maybe $30,000, but certainly not $5 million. And I'm being super generous. For all applicable statutory penalties, sure. For attorney's fees, he doesn't have an attorney. For cost of suit, yada, yada, jury by trial. And there you go. So that's garbage. And it's not going to go anywhere because, once again, he doesn't know what to do when he's filed the lawsuit. He doesn't know where to go from there. So I don't know how. I'm going to do this for about 15 minutes. We're going to reward the people who were in early. Chille did pay the filing fee, which is awesome. And I think he has to pay the filing fee because if he's going to do this as a informa pauperis, I think is what they call it in the federal courts, then the court would actually get to look at his complaint and see if it's frivolous or not, and that might F him over. So, Boo, hello, fake, good evening. Hey, Merb, yep, my lucky day. Well, if it was your lucky day today, I'm happy for you. Hi, I was hoping you'd do this. Well, I was hoping I'd do it too. Dang it, still not good enough to be sued by Chille. What's a girl got to do? Probably anal. The fish cannibalism intro is so Merb, never change, sir. Chille is suing for a violation of the trifold doctrine. Nice. Not sure if you're interested, but LDOF is live and going off on one of his mods that called him out. I don't know who LDOF is, but got to keep your mods in line. Clearly, Chille will prevail. Absolutely. Lol. Clearly, he'll prevail on this one. It doesn't stop. Yeet, yeet, yeet. Good evening. Hi. Hit that like button. Don't worry about it. Already did hit. Thank you. By the time Merb reads this comment, I will be in bed. Good night, losers. Good night, Big Daddy Ballbuster. Laughing. Merb reading and delete Law's lawsuit is my favorite entertainment. Well, I'm glad. Merblicious. I support free the sack, like free the nipple. Oh, it's free. There's going to be a sweaty, juicy butt stain on this couch. Good to see you. Hi, Merb. Hi, chat. Hi from Australia, mate. Isn't Officer Dingle from Reno 911? Is there an Officer Dingle? Hold on a second. Let me scroll back up there. Is there an Officer Dingle? Yes. I don't know. Reno 911 Officer Dangle. It's Officer Dangle. Oh, so close and yet so far. There you go. Dangle's on 911. It's 11 a.m. Yes. Any barbecue in a strip mall in Nevada sucks balls. Absolutely, my friend. Oh, thanks. He brings race into it. Yes, he does. I want to see the arrest body cam. Somebody had it. Biased against the mentally challenged. That's probably bad. Yo. It's 1 p.m. here in the land down under. And do the women snore and the men thunder? I forget what it is. Have some Vegemite. Sorry I'm late. Took longer to get the generator up and running than I expected. Had tornado cruise by a few miles away a little while ago. Well, I'm glad you're safe. It's perfect, like all these claims. They can use his own video for evidence against him. Yeah. Body cam is out. Just search it up. Yeah. What's it? Artie's corporate fiction had it. Hope ever. Well, he is gay, and the male officer searched his cookie. Well, a man in uniform can't go wrong, right? That's Officer Dangle. Chille's fun, I get it, but expose real scumbags. I don't expose scumbags. So there's where you're wrong. I talk about legal proceedings, and I call people out on hypocrisy. That's it. That's all I do. So you have to look for an ally somewhere else, sir. I have a friend in Aussie, but a different time zone. It's still AM by her. He would sue the moon if it did not come out at night. Rolls eyes. Oh, I was looking forward to your take on this pile of garbage. It's a pile of garbage. But, even if he did, honestly, even if he had a viable lawsuit, number one, I think he would be too proud to turn it over to a lawyer who might actually get him a recovery. And he still wouldn't know what to do. So even if he had a good one, it would still languish like the Ohio lawsuits languishing, like the Massachusetts lawsuits languishing, like his California lawsuits languishing. I mean, all he knows how to do is file a lawsuit. And it's like a football team that all they know how to do is hike the ball. And that's it. Like, hey, we can hike the ball really well. Well, you got to do something with it after that. And that's where it all falls apart. Hope everyone is okay. Hi, thanks. Flat Derp has a new vid out. Well, good. I support Chille's mission, but his mods dick ride too much and kiss his ass. I respect Chille, but some mods are in it. Well, I'm surprised. I'm surprised that a man born in the year 973 would really support Chille. Mikhail. Hi. Hope you're okay, Mark. How much money Kate Peters steal from her fans? I don't know. You tell me. Hi, Roseanne. Chilito claims the police were racist against him because Chille is white, not Hispanic. Riddle me that. Well, there were white officers too. Like I mean, just because you have a skin color does not mean that the only reason the police are interacting with you is because of your skin color. Now, there may be racist officers out there. There probably are. Probability would suggest there are racist officers out there. But, I mean, Chille went to them. They didn't come to him. Okay, in my immediate area, pretty much pasture and grassland, no direct contact with small towns. It went from rotation to funnel formation and scooted off to the boondocks. Flat Derp cracks me up. Funny stuff. Yeah. The last one I saw of his was pretty good. It was Chille doing a pole dance and he was riding. He had his butt crack up on the. It was pretty bad. Is the funny kind of bad, but I'm a 13-year-old at heart, so you don't have to hit the button. I don't really care. Good question. Chille went all in on brain cells in Ohio. Should have quit then, probably. Everyone, Jesus fucking Christ! I'm not going to read your shit anymore. I thought Kate raised somewhere near 50,000. I believe she's alleging that she raised like 49. I believe she spent like 60. So allegedly she spent 11 grand of her own money. I don't really know. Don't really care. I know she spent a lot and I know she still has an attorney. So she's probably spending more. That's good. That weather is coming our way, but it will just be thunderstorms. How does Chilito have time to write these long lawsuits? Didn't he say he was going to run for governor of Nevada? Well, I think you'd have to be I'm guessing you'd have to be a resident of Nevada first before he could run for governor. and he would probably want to be at least involved in a political party, and I don't think he is. I don't think he's going to run for anything. Go Tom. Go to Artie's Corporate Fiction. He has several different officers' body cams. The original officer plus several other police that were on the scene. Yes. Go to Artie's Corporate Fiction. Yes. Chille's argument is the city has officers. Yes, basically that is his argument. You'll be dumber at the end for having read that filing. Yes. I so hope this is uploaded when it happens. I so hope this is uploaded when that. Okay. At least he has good attention. Major Dingle. Dang, I just got here. I hope he didn't miss much. No, you didn't miss anything. I'd be upset if I got arrested by Dingle and Doolittle. And I think it'd be hilarious, personally. I'd probably want to frame the citation. Time to pretend I know what you're talking about and listen. Well, sure, have fun. He's going to run for governor of Ohio, Wyoming, Nevada, California, Texas, et cetera, et cetera. Yes, he probably will. I protest Ossifer Doolittle is innocent. Looking for Thursday night gay bar door fees. Well, if you're good looking, you can get in for free. I am surprised he hasn't declared in Kansas yet. Our only requirement is that we have one. Other than that, zero qualifications on age, residency, or anything. That's interesting. I'm surprised that anybody, even a non-resident, could run for governor of Kansas. Interesting. Excuse me, sir. You're wrong. My 1971 Ford F100 still runs. Thank you. And I'm not a good mechanic, and so runs. He's not soft on her at all. He has a glory hole invoice to pay. Probably. We may have misunderstood him, though. He could be running from all these governors, especially Ohio, where his warrant. Probably. The only thing worse than Chille's legal advice is his acting skills. I don't know. He could. All of this could be just one big act. It could be a long troll. And if so, it'd be genius. He has to win in Ohio so he can pardon himself, probably. That just falls into the et cetera category. He just hasn't declared it yet. That would explain a lot. He has two warrants in Ohio. Nice. He claimed press, constitutional law scholar, and corporate executive to the cops. I didn't remember the corporate executive during the arrest, but interesting. Did you see the body cam? You know what? I saw the one that already put out. So I think there was two there. I didn't spend a lot of time on it. 12B6. Chille struck him first from the vetoes I watched. Yes. I think laid back cops are probably the minority. Yes, they probably are the minority, but they shouldn't be. The problem. I think one of the big problems is that people who want to be police are the ones who try to be police. You know what I mean? Like people like, ooh, I want to do this job because I want the excitement. I want the adventure. I want to be able to tell people what to do. I want to have power, things like that. And it attracts the wrong people, I think. Not always. I mean, there are good police officers out there. There are bad police officers out there. There are, the whole spectrum on any given day. Probably his fifth run with Chille. Why does he always have 50 does? Okay, well, because you can sub those in. You can amend your complaint to add people as you find them. The real attorneys put does in just in case there's someone else involved. Like there was another. You look at the video footage. You thought there's only 5 officers, but actually there were 6 officers there, and it was the 6th unnamed officer that actually did the thing. So you've already filed your lawsuit. You don't want to have to file a whole new lawsuit or do anything like that. So you have the doe in there, you amend the complaint to add the doe. It just makes it easier. It's just it's a simpler procedure. Chille is governor. No, please no. If he ran in K, feet don't squeak like dog toys. His brain is really broken, isn't it? If he ran in Kansas, he would have to declare a party because we do not take independence seriously. Most places don't. Sadly, we have a uniparty that pretends to be two parties. Sometimes I think he overlooks the fact that his own video contradicts him. Yes, he loves to overlook that. See, the thing is, he gets to massage the facts as he narrates them. He can't massage the video. Bow chicka wow wow. I like Merv. He reminds me of my Brett, except Merv's got brains and isn't as scary, gully looking. Oh, I hate my life. Okay. Chille left out when told the cop he was a dog and to get back in his car. I guess that's Chille standing up for his rights. Yes, I'm clearly surprised at the lack of clearly in this complaint. I think the Harlequin romance novel publisher will be signing Chille shortly. Right. Officer menacing leans forward for a kiss. Action. Excellent. I'm running out of steam here, guys. Can the judge watch the body cam before laughing inside of court? Well, yeah. So probably on the 12B6 or the motion for summary judgment or something like that in the initial stages when it gets filed, because the body cams and Chille's video were alleged in the complaint, they could be deemed as incorporated into the complaint, and so they get to be part of a judgment on the pleadings or a summary judgment or a 12B6. So there you go. And he's got warrants in different states. Why can't they extradite him? They can. And this is what I was telling people all along, all the Chille bashing crew, that nobody's going to fucking extradite him over a goddamn misdemeanor or a bench warrant. They're not going to do it. They're not going to fucking do it. Like, they have bigger fish to fry. They have more things to do. They're not going to waste their fucking time and money to fly Chille back to Ohio for a failure to appear or a bench warrant or a misdemeanor. They're not going to do it. They can. Yes, they can. They don't. That's what I've been telling everybody. Like, anyway, that's it. Thanks for watching. Have a great night.